Okay, it's 1 o'clock. We're going to go ahead and get started. Our training is very full today, and we plan to have you out by 2 o'clock. My name is Vicki Suter. I'm the Director of Rights and Advocacy, also one of the individuals that help coordinate this training. I want to thank Mary Sheehan Bugard, who is also with us from the Michigan Department of Disabilities Council, who's very instrumental in helping us pull together this training series for us here in Oakland County. And then also Detroit Wayne Integrated Health Network, who's assisting us to get the word out and make sure that everybody who wants to learn about supported decision making has an opportunity to do that. So welcome to our training series. This is our May session. And let's go to the next slide.
Alrighty, just a bit of housekeeping before we get started. Just so everyone knows, this training is being recorded and it will be available on our website pretty shortly after today. So if you wish, or if you would like to share the training, people can view that afterwards. And all of our past trainings from the 2022 and 21 series are up on our website as well. This training has been approved for 1 social work CEU. If you are in need of that social work CEU or an attendance certificate, you must fill out the evaluation that I will send out in the end of the training in the chat. Depending on what version of Teams you have, your toolbar is going to be at the top or at the bottom. Since you're going to need to access the chat, let's talk about how to get there. So on your toolbar, there is going to be a little circle with 2 lines through it that says chat. You might have to look in your settings to hit show chat, but that's how you pop at the chat. Next to that is a little camera and a mic icon. If there is a line through it, that means it's off. We do ask that you keep yourself muted throughout the training just to cut down on background noise. However, we will pause for, questions periodically, so you can unmute yourself, of course, then, or you can use the chat feature to put your questions in the chat. I will be monitoring that throughout the training. It is totally up to you if you have your camera on today. Although we would love to see all of your wonderful faces, but it's totally up to you. You can have that on or off. Because this training is approved for 1 social work CEU, you must fill out the evaluation at the end of the training and be here present the entire time. If you arrive 5 minutes late or depart more than 5 minutes early, you forfeit those CEs. That wraps up my housekeeping for today. So Vicki, back to you.
All right, thanks. So thanks for attending. Thanks again to our partners. This has been a goal and a brainchild of the Oakland OCHN supported decision-making work group here locally. We are trying to make sure that all individuals know about the different tools and benefits of supported decision-making. And this is our 2nd year, as Caitlin has mentioned, of providing an educational series. So we're so happy that you've joined us. Next slide. So today we are going to talk about Special Needs Trust, what it is, how to use it, and how that helps individuals that are interested in supported decision-making. Our presenter today is Lisa Lapine. She's the Executive Director of ARC-O-Macomb County. She has been involved in helping persons with disabilities for many, many years. So we're grateful that she will present for us today, and I'm going to turn it over to Lisa.
Good afternoon, everybody. I hope everyone is well. We're going to cover a lot of topics pretty quickly, and I have an hour to do it. So on the first slide, if you can hit this slide, is my contact information. So if there's a topic that you have additional questions about or would like more information on, my phone number is on there. I'm at extension 101. And if you visit our website, they have the direct link to my personal email if you need to send me a follow-up email question. If you could page down, please. So in addition to being the director of the ARC-O-Macomb County, I'm also an attorney licensed to practice in the state of Michigan. And what we're going to talk about today is estate planning for people, particularly with the use of special needs trusts. There's 3 areas that we want to address while we go through this presentation. The first will be a little bit of a touch on benefits. The benefit piece is really important so you understand why a special needs trust is important. The second thing that we'll touch on is the vehicle which parents can use or families can use to get money to a special needs trust. And then the third issue we'll talk about is the special needs trust itself. All of these pieces kind of flow together like this in order to make a good plan for a family when we're talking with someone who is trying to support their loved one. But the most important question that I get on a regular basis is, who will care for my loved one when I am gone? It is imperative to understand that an estate plan is only one part of the entire process and one part of the entire group that will support a loved one after a family member is gone. We rely on the mental health system. We rely on support services from the Department of Human Services. So it's really, really important to understand that while we're going through the estate planning piece, this is something that we can put in place that will assist us with the financial management, but also gives us access to someone to help with decision making as a person is trying to navigate their world without family support or with different types of family support than what they had when they were younger. Next slide, please. When we plan because we want to make sure that we meet all of these purposes, that we make sure that we address legal, financial, and medical issues, that we maximize Social Security, Medicaid, and SSI, that we help with future living arrangements, inheritance, housing. We want to know that we're doing substitute decision-making or guardianship. We want to know that our community advocates are involved. We want to make sure that it's reviewed regularly, and we want to make sure that we're getting support services without an ability to pay. I was watching names as folks signed in, so I know that there are a number of people present who participate or work for the mental health system or for contracted agencies. So a lot of these things you're already going to know. These are planning things that we have to have in place if we're going to take care of someone. The next step is, next slide, please. When we're talking about estate planning, one of the biggest concerns that we have is, where are we going to get our sources of financial support? We might have individuals earning, someone might be working and earning their own wages. We might have government benefits. We might have family support or assistance, and we might have other. And when we put other into a presentation like this, the other we're talking about are things like back pay from Social Security, inheritance from someone other than parents, the opportunity, if someone wins a lottery. I know that that's silly, but I actually in my career have had someone hit for $15,000, which was really fun, but then causes problems for Medicaid and SSI. So we always want to know what the sources of financial support are for someone when we start working on an estate plan for them. Next slide, please. As many of you are aware, those benefits can be SSI, Medicaid, Social Security, Medicare, services from local agencies or authorities, for example, your local mental health agency, and the Department of Human Service programs. Next slide, please. The first important benefit that we have to understand for families is supplemental security income. And for supplemental security income, we're going to talk a little bit about eligibility. The eligibility for supplemental security income, or the supplemental security income, is provided to people once they prove a disability. A person who's applying for SSI must have less than $2,000 in exempt assets. Examples are, $2,000 in less than non-exempt assets. I got distracted. Did you guys see the slide that someone, or in the chat that someone said they're not seeing the slides change?
I did not see that, so thank you, Lisa.
Yep.
So the slides are up and present. They should be able, you should be able to see them change. If you are not, my recommendation to you would just be to leave the Teams meeting and pop right back in, and usually that resolves any issues. So that's my first troubleshoot step.
Thank you. So from the perspective of looking at how we are supporting folks, and we're looking at supplemental security income, what's important about this benefit, as I mentioned, is that we have to prove a disability exists in order to collect this benefit, and we must have less than $2,000 in non-exempt assets. Examples of exempt assets, because a person on SSI can own things, are a home that's owner occupied. And this issue can be a little bit tricky, because if a person owns a home on SSI and has help from other people to live there, we may have other additional issues, and we'll talk about that a little further in the presentation. Household goods and personal effects are not counted as exempt are counted as exempt assets, and a person can own a vehicle and still collect SSI. What's so important to me about SSI is that when you're Medicaid eligible, your Medicaid eligibility in Michigan is based on the same criteria used by the Social Security Administration for eligibility for supplemental security income. So if you're someone who's new to the system and you're worried about benefit application, we need to understand that SSI and Medicaid eligibility in Michigan go hand in hand. Next slide, please. Another benefit that's really important in our world of planning is Social Security disability income. Social Security disability income is an insurance that's paid to people who have earned work credits. The disability must have existed prior to the age of existed and been documented prior to the age of 22. And after you receive Social Security disability for 2 years, you have Medicare eligibility. The thing about SSDI and Medicare that makes it tricky for planning is that there is no asset test for Medicaid or Medicare. There is an earned income restriction and limitation, but there is no unearned income limitation. Next slide, please. But as an estate planning attorney or as a person who's helping people create estate plans or connect with attorneys who do so, the reason that benefit planning is so incredibly important is that Medicaid, which is asset limited, helps pay for long-term care in Michigan. So when we talk about asset limitations, we are most worried that we maintain eligibility for Medicaid in order to obtain long-term care. I just saw a question pop up in the chat regarding, is it an asset for Medicaid? And I'm making the assumption that the question is Social Security disability an asset for Medicaid purposes? So to walk that through, Social Security income per month counts against Medicaid eligibility, and continued collection of the Social Security counts against the asset limitation. And what I mean by that is Social Security disability comes into a person's life so that the person has a source of income to pay for food, clothing, and shelter. Each month when that check comes in, that person uses that money and spends down some of that money for their care. If we continue to collect that money in a bank account and allow it to accrue past $2,000, then it counts against the asset limitation. So if you save your Social Security disability or any amount of it and you exceed $2,000, yes, it counts as an asset. The check itself does not count as an asset. The check itself counts as income against the person who's receiving the benefits. So it can impact Medicaid eligibility for a person who's receiving Medicaid. What's important about Social Security disability, if a person is collecting it on a parent's work record, is that if they had SSI before disability, they can get an exemption and that Social Security will not count against their Medicaid eligibility each month. That's a little beyond what we're talking about here in this presentation. If it's something that you're seeing the people that you support running into, or if it's a question that you have for someone in your life, please feel free to contact me separately. And if we have additional questions and we have time at the end of the presentation, please feel free to ask it. More about it, I mean. So we've talked about benefit eligibility. And the reason that we talked about benefit eligibility and our concerns about it is that when we talk about estate planning, we have to worry about that asset limitation because we want Medicaid for long-term care. Next slide, please. It feels a little bumpy then to slide into estate planning because what does benefit eligibility have in regard, what does benefit eligibility have in regard to an estate planning issue? And the issue that it has is that, again, we want to stay below that $2,000 cash limitation if we're a Medicaid recipient and we are receiving services from the mental health system. The first slide here says is if I have a will, my estate avoids probate. And the answer to that is a tricky one. If you have a will, it's not a guarantee that your estate will avoid probate. So that would be false. Next slide, please. True or false? Estates can be arranged during lifetime so that no court is involved at the time of the death. And that would be true. We work really hard a lot of times to avoid probate court. There are pros and cons to going there, and it's going to be an individual question that you're going to communicate with your estate planning attorney when you make your decisions, but an estate can be arranged in such a way that it would avoid probate court in the future. Next slide, please. When you write a will, it's a ticket to probate court. Next slide, please. Your purpose for probate is to change legal title on your assets. Next slide, please. And I'm not sure why it's showing up a little different on my screen on yours, but in general, for an estate planning purposes, if you put everything you owned into one pot, that would be considered your gross estate. Within that pot, you have two types of assets, those that go to probate and those that do not. When you're talking about how you want to avoid probate, you have to know what type of assets make up your estate to make decisions. A probatable asset and non-probatable asset, because we like to use the same word and just throw an un or a non in front of it, they're easier to understand sometimes by giving descriptions or giving examples. For example, a non-probatable asset would be something like a life insurance policy, where if I have a policy and I name Vicky Suter as my beneficiary, if she's living when I pass away, that asset does not have to go to probate court because Vicky can collect it by showing her ID and showing my death certificate to the company because I named her as my beneficiary. So non-probatable assets are things that pass because we've got a beneficiary named on it, a joint owner named on it who's still living, or we have a way to transfer it upon death that says this is the person who receives it if anything happens to me. A probatable asset is an asset that has someone's name on it, that when that person passes, we haven't indicated a way for it to get to the next person. As a single person, if I have a savings account and I don't name a joint owner or a successor beneficiary, that asset then goes from my name to whom upon my death. If I've not named anyone on it, it has to go to probate court for the court to determine my heirs. If I have written a will, it goes to probate court and the will tells the court who I've named as my heirs and the people to manage my assets. Next slide, please. So generally, when we're creating a situation where we don't want to go to probate court, we look at ways to say who is going to collect this asset if not for me. One way is through joint tenancy. I put someone else's name on it and they own it if something happens to me. A pay on death account, again, I name a beneficiary, or a pay on death on an account, a bank account or a credit union account, and I say it goes to Vicky Suter if something happens to me. I give my money away before I pass away, or I can create a trust. Next slide, please. Why not create tenancies by the entireties? That's where someone is receiving a part of something. And why not just use it as a situation or a final way for that asset to be transferred? One of the most important things is to recognize that when we do estate planning, we're trying to take into consideration all possibilities of what might happen if someone passes away. So if we do a situation where everything goes to our spouse and we do no planning after the spouse, it doesn't take into consideration that awful thing if both spouses pass, and it doesn't take into consideration what happens after the second spouse passes. If we don't make any plans and there's an accident when both are included in that accident, then we certainly don't have a plan. And sometimes when a spouse passes away, the surviving spouse has difficulty moving forward to make a plan because of their grief. Next slide, please. Joint tenancies between parent and children can sometimes have some challenges as well, because when you add someone's name to your account, you're making them an owner with you. So if I have a bank account and I would like to pass it to Vicky upon my death, and I put her name on it while I'm living, that account belongs to Vicky just as much as it belongs to me. So if Vicky would like to go to Vegas and take my money, she can do so because her name is on my account. Additionally, if Vicky had debts and she were sued, then potentially someone could say to me, well, that account has Vicky's name on it, and we think that we should cover those debts by collecting from that account. So tenancy, by the joint tenancy between a parent and an adult child, can be a challenge. Next slide, please. One of the reasons that I like using trusts in those situations is that we avoid probate court with that trust and the grantors don't lose control. So what I mean by this is when you're doing an estate plan for any client and you sit down with them and you assess their needs, you look at the totality of their circumstances, which includes looking at what type of assets make up their estate, what type of needs that they have for their adult children that they'll be leaving behind, and who they have in their world to help fulfill their responsibilities or obligations. When we have an estate that has assets that might need to go to probate court, one way we can avoid doing so is by writing a trust. A trust is a document that says who's going to inherit after a person is gone, who's going to manage while that person is alive, and who's going to be getting what amount of monies after a person is deceased. So for example, if a husband and wife come in and create a joint trust, this trust usually or typically will say, if anything happens to the wife, the husband is in charge and retains control. And if something happens to both the husband and wife, the distribution provision is outlined within the trust saying who gets what. Also within that trust, it says who's going to manage things. So for example, I might say my son Joe will manage my estate if something happens to both my husband and I. And if Joe's not available, then Sue. And if Sue's not available, then Huntington Bank. We can then choose who's going to manage our assets if anything happens to us. The way a trust works, though, in comparison to a will, is that after the trust is written, funding has to take place. And what that means is taking all of those assets that you had that were probatable and retitling them in the name of the trust. I'm giving a real simplistic overview to a pretty difficult topic, but to give you a practical example of it, you might say on a life insurance policy, instead of having it pay out to a spouse, the life insurance policy would pay to a trust. If the trust is named as the beneficiary and both the husband and wife pass at the same time, that life insurance pays into the trust, and the trust, the person who manages that trust then has control of it to hand it out to whoever the husband and wife said. The reason that this is so important is that we're avoiding that probate process and we're making sure that our money flows from our hands to our children's hands, no matter what their age might be. So when we talk about who inherits and how they inherit, what's so important is that if we're talking about a family who has a child with a disability, we might also choose to do a special needs trust, and we'll get to that in just 1 second. Next slide, please. This is just a funding of a trust where you have the little, I don't know what that little design is called, but it pretends that that four-cornered thing that's not a square is the trust. That trust is receiving assets from real estate, bank accounts, stocks, bonds, all property, and it's going into the trust. The trust is then saying who receives that asset from the trust. And as long as those assets are funded into that trust, we don't have to go to probate court. I want to add a little bit of a caveat here and make sure that I say this out loud. All estate planning attorneys have different ways of planning, and each client's situation presents different fact patterns. So whether a trust is most perfect for a client is going to depend on that person's needs. In regard to this particular training, we talked first about benefits, Social Security, SSI, and Medicaid, and the need to maintain Medicaid eligibility for a person who's receiving supports from the mental health system. We talk about how we can transfer those assets to the next generation by using a will or a trust. And when a trust is more important is when we want to avoid probate court. And if we don't mind going to probate court, we would use a will. But all of this is leading up to how the benefits are important for eligibility. The trust is important for the vehicle to get the money to the individuals who are inheriting. But next slide, please. The real important piece that we want to talk about here today are special needs trusts and what special needs trusts do for families. The initial introduction to how do we fund them is important so that you have an understanding of how does it get there. But what we're most worried about when we're talking about what we're most concerned about today is special needs trusts and how or what does a special needs trust do. For a person with a disability or an adult child with a disability, what's really important about a properly drafted special needs trust is that it preserves Medicaid and SSI eligibility. In a lot of cases, it provides for a quality of life because a lot of the benefits that our folks received are capped or have limits to them. So special needs trusts are a way for us to provide for additional or extra items for an individual who may be dependent on a benefit structure that has limited means available to it. And finally, it allows for the trustee to act as an advocate, and we'll talk a little bit more about this as we go along. Next slide, please. There are different types of special needs trusts out there, but what makes a special needs trust is that it's solely for the benefit of the individual that it was written for. In Michigan, trustees have sole, uncontrolled, or unfettered discretion. What that means is that a trustee is supposed to manage those assets on behalf of the person with a disability, but they have the ability to say no to a distribution or no to something for the beneficiary if it's outside the scope of what should be paid for. A trustee can make distributions to any third party without consequence. There's one exception. Sometimes funding from a special needs trust can impact subsidized housing, and that's an important exception when it comes to the MyAble account that we'll address when we get to MyAble accounts. One thing about special needs trusts is that they can't give cash to the beneficiary. So if I'm the trustee of a special needs trust and an individual asks me for $100, I'm not going to be able to turn over and give $100. But what I could do would be to have a conversation about what that $100 would be purchased for, and perhaps make arrangements with someone to buy what that person is looking for the $100 for. For example, I want Yu-Gi-Oh cards. I want to trade them when I go to the next ComCon convention, and I don't have $100 to buy my Yu-Gi-Oh cards. Perhaps I can arrange to purchase the Yu-Gi-Oh cards for the individual without giving them the cash just directly. And then one of the things that's nice about a third-party special needs trust is that grantors can name contingent beneficiaries when pre-planning occurs. I'm going to divert from the slides just a little bit here and talk about what I mean about grantors and third parties and first parties. Special needs trusts in general are vehicles used to allow an individual to continue to maintain benefit eligibility so that the money from wherever it comes from doesn't impact a person's eligibility for SSI or Medicaid. Remember earlier I mentioned that assets don't count against Social Security eligibility. They only count against those needs-based benefits of Medicaid and SSI. So what happens with a special needs trust is that money that transfers into the trust are given special exceptions under state and federal law to say that those assets held within that trust do not count against those needs-based benefits. And the reason that they don't count against those needs-based benefits is that the individual who is benefiting from the trust lacks the ability to demand or control the assets within it. And the trust assets are meant to be spent in specific ways so that they don't impact or upset benefit eligibility. Meaning benefits are for food, clothing, and shelter, and the trust is for extra or supplemental things that the benefits don't cover. So when a person is receiving something from a special needs trust, a trustee really needs to look at what benefits that person is bringing in, how their needs are being met, and how the trust can complement, not be substituted for those benefits. There are two types of special needs trusts in planning circles. There are first-party special needs trusts and third-party special needs trusts. When you're dealing with someone who's using a special needs trust, it's important to know the difference between the two. A third-party special needs trust is a trust that was established from money somewhere other than the individual. So, for example, as a parent of someone with a disability, I'm a third-party person when I fund a trust. I create a trust, I put my money in it, I'm a third party. My child who has a disability is a first party. if my child who is a first party inherits from me before I create a special needs trust, my child can still create a special needs trust, but there's going to be different rules in its implementation, in its distribution at the end of life. When there is a third party plan in place with a special needs trust, I, as the grantor, get to control who manages the money and who receives the money if there's anything left when the beneficiary, my daughter, dies. On a first party special needs trust, the money came into my daughter's hands. She holds those assets and we are transferring them into the trust. And the government says, I'm going to allow you to do this, but in order to do that, there's going to be some repercussions. There are different types of choices to choose from when there's a first party money, but in most cases, those first parties require that the state of Michigan be paid back for cost of care, or in the situation with the pooled accounts trust, any money put in there would be retained to help other people with disabilities. So we can protect assets if they go into someone's name without having a special needs trust in place initially, but there are some repercussions for them. In general, though, all special needs trusts vest total authority in the trustee over the management of those assets, and the trustee has a duty or a responsibility or financial obligation to make sure that they're looking out for the best interest of that beneficiary. Next slide, please. So in this particular presentation, we're talking primarily about special needs trusts that are funded by third parties, meaning that a family is setting up a plan prior to their set of parents, or a parent is setting up a plan that says that my assets are being transferred either by will or trust of my own into a special needs trust. And that special needs trust can also receive gifts from grandparents and other family members, or contributions from other family members. Next slide, please. So how it works. And again, this particular presentation is really focusing on the idea that a family is doing some pre-planning versus necessarily first-party trusts. But in general, what happens with a trust itself is once it's funded, from whatever source it's funded from, that trust can own a house. And if it owns a house, the individuals living there would pay rent to that trust. And that trust can then pick up the extras that might not be affordable to a person outside of a trust relationship. So for example, it's a really nice way to be able to afford housing that might be different than what someone could afford if they only had Social Security benefits. Practical example, if I have two SSI recipients and they're each receiving $864 a month, and they need to rent an apartment, it can be very difficult to find an apartment and be able to pay the utilities and all of the shelter costs with just that $864 a month. But if a family member were to buy a house and transfer it to a special needs trust, the special needs trust gets to set the rent at whatever is affordable to the trust itself. So a beneficiary might be allowed to pay $200 a month in rent, and their roommate pays $200 a month in rent, and that will give them more flexibility in the $864 a month that would allow them to continue to meet their needs. Vicki, I see your hand.
Yeah, so would that rent money then go into the trust?
Yes.
Okay.
Because the house is owned by the trust, and the trustee is the landlord. So the rent would go into the trust, and that would give the ability for the trustee to use those funds to defray costs that were appropriate under law, for example, property taxes or homeowners insurance, or to pay for a new roof if there's additional funding in the trust from inheritance. So it's a nice way to be able to balance benefits from the federal government and what the family is allowed to leave and still maintain eligibility for those benefits. Next slide, please. So what really makes a special needs trust, or why create a special needs trust now? Well, for families who are planning for the future, one of the most important things that's not even there and on the slide is just feeling comfortable that they've put something in place to make sure that the needs of their loved ones are met when they're no longer here to meet those needs alone. Planning for families takes an extraordinarily long time, and many families put lots of time and energy in it to make sure that they're making the best choices for their loved ones. And sometimes those choices change throughout life. For example, it may be that you think that a sibling would be a very good trustee, and you name that sibling as a trustee, and then they have their own child with a disability, and their ability to assist their sibling changes. Perhaps you choose a bank and the bank changes ownership. So when you're creating a special needs trust ahead of time and you're planning, you're able to put the pieces in place and have influence over it, over the choices of who's doing what. In addition, it gives us some additional planning tools. If there's a family member who needs long-term care, specifically a parent, it may give us a vehicle that we can transfer assets to in order for us to qualify for Medicaid and still preserve some assets for our loved one. In addition, preparing now might give you the other family members an opportunity to leave a gift. For example, working with families, there will be times when an aunt or an uncle might like to leave a gift to their nieces and nephews. And when we're planning for someone who has an SSI or Medicaid cap, we might gently want to inform them that the way to do so to keep them eligible for benefits would be to use the special needs trust. Additionally, sometimes siblings, if they're not married, would like to leave something to their sister or brother. So if we pre-plan, we're giving them the opportunity to allow their loved one to inherit from them. And that's how you can take advantage of planning that's beneficial for the entire family. The next slide, please. This slide addresses the idea of OBRA 93 Exception A and Exception C trusts. These are the first party trusts I mentioned that are available to us under law that gives the remainder back to the state or to a charity in the event that an individual is trying to shelter assets to stay SSI or Medicaid eligible. But really what's important here are my ABLE accounts. So again, going back to the idea that every client and every person has different planning needs or planning objectives, my ABLE accounts can be very, very, very productive ways for people to leave additional funds to their loved one and for their loved one to contribute. There are yearly and lifetime contribution limitations based on whether the person is an SSI or a Social Security recipient, but the individual can contribute too if they're having asset limitation issues. For example, they get Social Security each month and they have wages, and every 2 months they have an asset problem and they have close to $2,000. My ABLE accounts are a nice way to put some money aside and be able to contribute to so that a person has the ability to save. They also offer a debit card option, which is kind of neat for those people who are learning to manage money and who would need some assistance, who would be able to manage their debit card so that they could take it with them and pay for things from the trust when they had other expenses that exceeded their Social Security payments. And then there's tax benefits to people who contribute to my ABLE accounts. They can be a really, really valuable tool. The key to a my ABLE account, though, is that, again, the state of it's administered through a company chosen by the state of Michigan, and any money left upon the individual's passing it may be required to pay back any Medicaid liens. I said may. A complete estate plan always includes, in my opinion, a power of attorney, patient advocate designations, pour over wills, and letters of intent. Next slide, please. And then if you hit it again, because I went really fast and forgot to say next slide, please.
Lisa, can I ask just sort of a practical question before
Sure.
you go on? So you have a special needs trust, you set it up, and then it gets funded. So
It gets funded when the people pass away.
Correct. So then those funds, how are they held? Are they held in a bank account under the name of a trust?
Yes, they can. Okay, so what happens, and that's a really great question, Vicki. Let me kind of put my hands up and explain it with my hands, okay? When people pass away and the trustee of their trust or the personal representative of their will administer their estate, they take the funds and they distribute them according to the wishes that the person wrote in their documents. And whatever percentage is left to the special needs trust is transferred to the trustee of the special needs trust, who is then responsible for establishing an account to hold those assets. As the trustee of the special needs trust, you of course want to set up some kind of account, like a checking account, so you can make sure that you can pay out things, but you can also invest those monies with various investment companies or financial planners. But any account that you hold for the person who is the beneficiary of the special needs trust needs to be in the name of the special needs trust. So if I've created the Lisa Lapine Special Needs Trust, then I can have a money market account with Morgan Stanley, and it's called the Lisa Lapine Special Needs Trust Money Market Account. And if I have a checking account at Comerica, it's the Lisa Lapine Special Needs Trust checking account at Comerica.
Okay.
The trustee then can write checks out of the checking account and work with the financial investor to invest, but the accounts are held in the name of the trust, which is identified by a tax ID number separate from the individual, so it's not considered their asset for benefit purposes. Does that help?
Yes, thank you.
Okay.
Which
So-
so that leads me to you mentioned sort of taxes. So does a special needs trust, do you have to file any kind of IRS or state or
Absolutely. A special needs trust is, it's like a little business. It gets a tax ID number and it has to file taxes each year. And whether taxes are paid is determined on how much income is made and how many distributions are made. So anytime you're dealing with a special needs trust, my recommendation is that you also find a good CPA to help you assess whether taxes are due each year on a special needs trust. What's a trustee of a special needs trust needs to be a specific or a special kind of fiduciary. They need to be a person who, one, understands the beneficiary or knows the beneficiary, but also knows that they have to file taxes and that they need to be able to communicate with support coordinators, providers, other family members, and they need to be able to be sure that they're understanding what implications there are for Social Security, the Department of Human Services and Medicaid, adult home help and food stamps, and Section 8 housing whenever they're making a distribution. What's important about picking your trustee is knowing that when you pick that person, you're picking someone who's going to look for help if they need help when they're doing their administration, versus necessarily someone who's going to know all the answers to all the questions. So I might say, Vicki, I choose you to be my trustee, but I would be expecting that Vicki would understand her limitations about how to manage and to secure assistance from all these financial professionals. In a really, really well drawn out plan, next slide, please. A family member is also going to do a letter of intent. And that letter of intent is going to be specific about many things: housing, education, transportation. Next slide. Healthcare, quality of life, real employment. But another part of that letter of intent can be a letter of instruction about who you, as the grantor or the person establishing these documents, feels comfortable in trusting important life decisions to. Who is your attorney? Who is your financial planner? Who are the people in your life that you felt comfortable making decisions and choices as we draw the circle of support around the individual that we're supporting, who is your child, and who you know are going to make decisions in your child's best interest? When we talk about supported decision making, which is why we started talking about special needs trusts in the first place, the most important thing about supported decision making is recognizing that individuals make decisions all the time that require input or include input from other folks. What we're doing when we do special needs planning is providing for additional funds for a person to continue having the lifestyle that they had when their parents were living. But what's even more important about it is we're helping draw that circle of support around our loved one so that that individual has people that they can rely on to help make important decisions and choices throughout their life and have the necessary funds to achieve their objective. We have many people in our world who are vulnerable to other people taking advantage or making bad choices. So a trustee is another person who can help someone with how do we make good choices with the situations that we're presented with. Next slide down, please. Not everyone has a special needs trust. Some people don't know they exist. Families are the best way to share information amongst one another. So if you don't have a strong parent support group, sometimes the family hasn't heard or doesn't know that these even exist or that it can be done. Trusts are kind of scary because it's hard to understand or grasp the concept behind them a lot of times. So some folks, when we sit down and talk, their biggest fear is that they're going to lose control of the asset or management of their assets while they're doing their planning during life. Sometimes court intervention may be advantageous. Sometimes we have family members who are going to argue and fight, and we want the judge to say, do this or do that. In a special needs trust situation or in a trust situation, if a family doesn't follow through and fund the trust, initially the trust for the parents, assets are, if they're not transferred, the plan doesn't work. We still end up in probate court. So it's really important to understand that funding a trust is an important part of trust planning. Affordability is a big issue. There are so many great attorneys out there who do planning in this area. And both the Arc of Oakland County and the Arc of Macomb carry lists of attorneys who practice in this area. Every attorney sets their rate based on what they think is appropriate. So affordability can be an issue depending on where you're shopping for this service. And procrastination, and this one is the one that's on the bottom because one is procrastination, and two, a lot of times we think to ourselves, yeah, I'm not going to worry about that because I'm not going to die. Well, we are, number one, and number two, we don't know when. So we procrastinate because one, we don't think anybody can do it as well as we can for our children. We think as parents that we are going to be here forever and a day, if that's what it takes. And we don't want to think about the time when we won't be here to do it. So we put it off on the back burner because there's so much that our kids need that we don't get to it. Next slide. This topic, this is my thank you slide with questions. Let me tell you, this topic is something that I do in presentations for sometimes 2 hours at a time. So this was quick in 48 minutes. So are there questions or things that were missed over or someone would like more information on? Well, we have a few minutes left here. I see a gentleman's hand up, but I don't know his name.
That's Richard. Go ahead, Richard. You got to unmute. Yeah, you're still muted. So
Okay.
There you go.
So I have a special needs trust administered by somebody else, and I have 2 checking accounts, and I have SSDI coming in every month, and I pay my rent out of these checking accounts that I own, but I'm constantly going over $2,000. Can I move these checking accounts into the special needs trust and still be able to use the checking account like my own checking account?
So if those checking accounts are with Social Security money, the answer to that is no. What you would want, and Richard, this might be something you want to talk, I can give you some suggestions or ideas, but if you'd like to call me and specifically speak about it in more detail, I'd be happy to do so.
Okay.
But remember we talked about there's 2 types of special needs trusts, first party and third party. So the first question would be, if the special needs trust you have is a third party, you cannot add your first party money to it without breaking a rule. The second thing is that if you are constantly going over assets in your two checking accounts, is it the best place to put your money? Would my Able account be a better place to put it? Okay.
I have a MyAble account.
So then I would probably be adding to the MyAble account, but I want to add the caveat to your question that I don't know much about your special needs trust. So if you want to give me a call separately from this, I can give you a little bit better guidance, or I can point you in the direction of some attorneys who could help you as well, okay?
Okay. But the general answer is, if my Social Security disability is going into that checking account can't be transferred into the trust.
Correct. Because your Social Security needs to be used for food and shelter first. And if you're coming over assets regularly, whether it can go into the special, whether you can cut a check for the excess assets would be dependent on what type of trust you have.
Now, the other checking account that isn't funded by Social Security, that could be moved into the trust.
Same answer. It depends on where the money comes from and what type of special needs trust that you have. Because if the special needs trust is funded by a third party, then none of your money can ever go into it from any source.
So thank you, Richard. I think that's one of the good things that I learned today was the difference between the first party and third party trust. So I didn't really understand that there was different types and some of the parameters around that. So that was, to me, very interesting piece of information.
And Richard, if you have follow-up, please feel free to give me a call separately, okay?
Mm-hmm.
All right, somebody else, Rahul?
Yes, I sorry, I missed most of the presentation because my calendar was messed up. When is your next presentation?
For special needs trusts?
Yes.
Do you have one scheduled, Vicki? Because I can answer that from the Arc of Macomb's perspective.
We do not have an additional one scheduled for our Oakland County sessions. Mary, I don't know if anybody in your group does, and then or Lisa, yours as well. So
I see. Would you be able to? Do you guys happen to share the slides?
We do record these sessions, and just in a few minutes here, I'm going to tell you where you can find the recording, so you could actually listen to this.
Oh, that would be fantastic. That's good enough, you know.
Okay.
At my own time.
And
Okay.
Lisa, if you
So
want to.
are you gonna put it in an email? Because I would like to listen to it with my husband. I didn't get anything. I'm dizzy from it.
Yeah, yeah.
First
So
time.
yeah, we'll show you where you can find it on our website here in a few slides. And then also, Lisa, if you want to put information about when you'll be doing a presentation like this again for the Oakland.
Well, actually, what I was going to encourage everybody is to please check the Arc of Oakland County's website or the Arc of Macomb County's website, because we publish our calendars for presentations on our websites. In addition, I know that the director at the Arc of Macomb and myself will always sit down and give general information to folks, and if they would like to sit down and do it individually.
Yeah, I believe we have somebody that's joined us from the Arc of Oakland. And so Christy, if you want to, in the chat, if you want to put your website, that would be great.
I can absolutely do that.
Thank you.
Yeah, no problem.
DD Council will also be sponsoring a presentation later on this year. We don't have the specific dates yet because I was waiting for to talk to Lisa about maybe presenting. We have another community mental health Bay, Aranac, who is interested in doing a series of presentations. So you can watch the Michigan Developmental Disabilities Council Facebook page, and we'll have an advertisement when we're ready to open registrations for that one as well.
Mm-hmm. Yep.
Lisa, do you work with the Arc of Oakland County?
The Arc of Oakland County and the Arc of Macomb County partner often on these topics and issues, and we also both keep lists of attorneys who practice in this area.
Okay.
I wanted to mention, that's something that if you contact each of us, we can provide as well. So we help one another out, and we both do those presentations, and we both keep lists.
Lisa's the executive director of the ARC of Macomb.
Okay.
Dawn Calnan is the director of ARC of Oakland.
Okay,
Both great people. So,
okay, because I got this one from my social worker.
okay.
So, okay, thank you.
So,
It was eye-opening.
yeah, so I'd like to offer a word of encouragement for those of you that, you listen to this and you're like, ooh, my head's hurting.
Yes.
So I have listened and agree. First time I listened to it, it's like I had blank spaces and I didn't know what to ask. But
Yeah.
I've listened to this presentation probably 2 or 3 times, and each time I listen to it, I pick up something new. And I've actually and I have gone through part of the process of my brother was setting up a special needs trust for his son, who's 9 right now. He hasn't quite completed that, but he actually had me review the documents from the attorney. And so even when I was reading those, and and that was helpful just because I got a little bit more familiar with what it's going to look like in the documents, but I still had questions or gaps. And so each time I listen to a presentation or somebody talks about this topic, I gain something new about it. So don't feel like, after one presentation, you feel bad because you're not getting it, or it's not, all the dots are not connected. And particularly that's why I asked Lisa about, okay, once the special needs trust is funded, then where does the money go? Because that was a gap for me. It's like, okay, does it go in a checking account? How exactly does that have to be done? So each time I've listened to it, I've gained something and then had a question to fill in my blanks.
Okay. Yeah.
And I would just like to add, if you count all the professionals on this list of participants today, we probably have, 30, 40, 50 degrees between us all. And I have listened to this, as Vicki has said, several times. And I'm constantly rethinking, oh, okay, so for my brother who has, an ABLE account, how does that work in conjunction with, special needs trust? And do we need to have both, or could we just have one? And every time I hear you, Lisa, I gain more knowledge. And so, I wanted to reiterate what Vicki was saying. This is a lot of stuff, and it takes a while to kind of hear it all, process it all, and then figure out how it impacts your loved one.
Yes. So thank you.
I'd like to add just one more thing to all of the conversation here. When you choose an attorney and you're going through this process, it's a very personal thing to you. And one of the things I say in almost every presentation, so I can't skip it here, attorneys are like clothes. If we don't fit, you shouldn't wear us. There are times when there are attorneys who know certain things or practice a certain way that are different from others. You have to find the attorney that's best for you. So that's why I encourage you, give us a call, sit down with us, but there are lots of very, very knowledgeable attorneys out there who can assist with us, and it's finding the perfect one for you while you're going through this process that's really important.
Thanks, Lisa. That's an important piece. So as we conclude, just a reminder that we do offer one social work CEU. We do need to complete the survey at the end of this training, which will be put in the chat here shortly. Next slide. As I mentioned, we are conducting a series. So in June, we'll be talking about the intersection of employment and public benefits. Can I work and keep my public benefits? So there's information to be gleaned about being able to work and not impacting your public benefits like Social Security and Medicaid. In July, we're going to be talking about medical situations and what kinds of things you can use in supported decision-making related to medical situations, types of assisted technology that can support people so that they can remain in the community and be as inclusive and interdependent as possible. September, we're going to talk about, some people may have some guardianships and they may want to know how do you get out of it? How do you terminate guardianships? We've had more and more, we're getting more questions on that. So we decided to do a session on that. And then in October, for the past year and a half, we've been working on a toolkit that's going to put all these resources into a toolkit for individuals to have as a resource. And we hope to be presenting that toolkit in October. Next slide. Here's where you can find the recordings of these sessions that we did in 2021 as well as 2022. If you go to our website, www.oaklandchn.org, resources and the recorded training, and then scroll down to supported decision-making webinars, you will find them there. I believe Caitlin usually puts that in the chat, the link to it. So you'll be able to find that. So those are great. This year's, all of our sessions are 1 hour. Last year, they were an hour and a half. So just FYI, if you're going to go listen to those recordings. Next slide. Thanks for attending our session. We so much appreciate you being with us and asking questions and offering your comments. The survey is in the chat. If you would link to the survey and complete that, that would be great. So thanks for joining us. Thanks for Lisa for the great presentation and all of you for attending with us today. Thank you so much. Hope to see you at some of our next sessions.